Well, as promised, we have Anthropic's motion for summary judgment in Concord v. Anthropic. And if you remember, we were just talking about this because they kind of exposed UMG's lies when they told their shareholders that, hey, AI is not a problem. In fact, it'll be a net benefit from us. Yeah, the competition isn't anything. No one's listening at all. And it's exactly the opposite of what their experts are saying in these cases. But I mentioned that Cox was going to come into play. I was right. So let's get into it. Most of this will be skipping over because it's kind of the same thing we've covered in other cases. Two of which they start off referencing the only two courts to consider the issue have both held that using copyrighted text to train a generative AI model like Claude is among the most transformative uses many of us will see in our lifetimes. You remember me quoting, I've quoted that several times from Bartz v. Anthropic, and they also mentioned Cadre v. Meta. We went over all those months ago. If AI training isn't transformative, then nothing is. Which means that fair use is dead. That's been my main motivation in covering all of this. Because if we don't have fair use, we don't have freedom of speech. And then the big corporations can control everything we say online. That's why this is so important. Claude, in short, is the kind of new idea that the Copyright Act not only allows, but encourages as a necessary counterbalance to prevent stifling the very creativity which that law is designed to foster. Allowing copyright holders to veto such a transformative technology would ignore the Supreme Court's mandate that the primary objective of copyright is not to reward the author, but to serve the public. Let me say that again. The primary objective of copyright is not to reward the author, but to serve the public. And it would frustrate rather than fulfill the constitutional command to promote the progress of science and useful arts. Because remember, that's the actual power of government in the Constitution. Promote the progress of science and useful arts. Copyrights and patents are just the method the Constitution uses to allow them to do that. But it does mean that any copyright law that goes beyond that is unconstitutional because you're going beyond that power. Because publishers cannot seriously contest that training is transformative, they largely rely on the fourth statutory factor, which weighs harm to the rights holder, which is basically, hey, you didn't pay us a license. You're supposed to pay money to use all of that. But courts have long recognized that the transformative use of a copyrighted work does not, by definition, require a license. You don't need permission to exercise your fair use. That's kind of the situation they've managed to manipulate on YouTube. If you've ever gone through this, someone makes a copyright claim, you come back, hey, this is fair use. They send it back and YouTube comes back, well, the copyright holder doesn't agree that it's fair use, so it's still copyrighted, so they still get the money. It's not up to them. The whole point of fair use is it's not up to them. And publishers claim that they will purportedly face competition from people using Claude to create original lyrics is legally irrelevant. The fair use inquiry is anchored on the problem of substitution, not competition. It asks if the defendant used an original work to achieve a purpose that is the same as or highly similar to that of the original work, not whether a transformative use facilitated the entry of a new competitor, such as a musician writing song lyrics. That's been the complaint. Oh, people will just use AI to write thousands of books and they'll compete with ours. So what? Write better books. If it is true that AI is slop, people won't want to read them. Publishers fail to show that any of the prompts that generated the few purportedly infringing outputs were submitted by bona fide third parties as opposed to publishers' agents. But as a matter of law, rights holders cannot infringe their own copyrights. We saw that crap over in the Disney case, right? Where they were using Midjourney to go, oh, look, we made Minions. Oh, look, we made Shrek. Look, there's all this infringing stuff. No, it's not. Because you had your people do it. Reed Southern and that other guy. I forget his name. They created all of those at the request of the plaintiffs. That's not infringing because they had permission. That whole long list of pages I scrolled through that showed you all of the Disney stuff and everything, not a single one of those images was infringing. Not a one. And there is no evidence suggesting Anthropic took steps to encourage its users to infringe publishers' purported copyrights or tailored Claude for infringement. To the contrary, Anthropic has long had guardrails protecting against reproduction of copyrighted text. It makes no sense for a user to pay Anthropic for a Claude account and then work to jailbreak its guardrails to obtain song lyrics that are available for free on the internet. Yeah, just go to Genius Lyrics. You can get them. You don't need Claude for that. Oh, and then we have the CMI crap. The DMCA is narrowly tailored to bar the removal of CMI where the removal is done to enable or conceal infringement. Even after almost 2 years of discovery, publishers have not identified a single work in suit from which Anthropic removed CMI. Nor have they shown that Anthropic did so with the double scienter the DMCA requires. This just happened over in the Getty Images case. I won't cover it because there's not much to say other than what I'm about to say, which is this was a motion to dismiss. This is much earlier than this summary judgment. Summary judgment is after you've developed a case after a while. Motion to dismiss is when you come in initially and say, Your Honor, they got nothing, get rid of it. The judge in the Getty Images case let most of the charges stand, but dropped the CMI. It was like, nope, that's ridiculous. And hopefully in other cases they'll take judicial notice of that. Because a motion to dismiss is a very low bar to have to get over, and they couldn't even make that. Publishers do not meaningfully dispute that training on lyrics and other copyrighted text is transformative. And even if publishers' theories of market harm were legally viable, they are not. Publishers have not met their burden to show undisputed market harm. Indeed, just last month, UMG, the parent of 2 publishers who collectively assert 448 of the 499 works in suit, admitted that we're seeing no indication that AI royalty dilution is a material issue for UMG from a revenue perspective. You remember that? I even played those clips. Oh, that was fun. He just destroyed everything. That Q4 earnings call, they destroyed all their cases. They really did. Alright, not going to go over all the stuff in detail, just basically summarize the fair use points. The use of lyrics as inputs is fair use as a matter of law. The first factor favors fair use. Training LLMs is transformative. Spectacularly so! According to Judge Alsop. May he enjoy his retirement. The second factor favors fair use because publishers make their claimed song lyrics broadly available to the public for free. So they can't really have been said to have lost that, can they? Anthropic only uses the portion of the works reasonably necessary to achieve its transformative purpose. Because remember, AIs, you gotta give it a whole bunch of stuff to train on. They need a massive corpus of stuff to learn with. And the fourth factor favors fair use because Anthropic's use of lyrics to train LLMs does not harm any cognizable market. Because remember, there isn't one. Oh, we've got one coming up. Stay tuned for this. In the Suno case, the plaintiffs are going to try to conjure up a market out of thin air. And the way they're trying to do it is pretty outrageous. And speaking of conjuring up stuff out of nowhere, knowing they fight an uphill battle on fair use, publishers resort to fabricating a new requirement from whole cloth, insisting that the fair use inquiry turns on whether the use is made by a human or machine. But humans at Anthropic invented Claude and continue to improve Claude every day, and humans prompt Claude for assistance with countless projects, including creative ones. On both ends, it is the action of humans that matters. Claude is nothing but a tool for humans. People need to remember that about AI. In any case, the fair use statute simply contains no human or expressive activity requirement, nor does the case law. Publishers' lone purported counter-authority, Thaler v. Perlmutter, does not even address fair use. You remember that? We covered this. This is where the guy made that AI called Creativity Machine. and he used it to make a picture, and it wasn't even like Stable Diffusion. There was no prompting or anything. He just ran the algorithm and it made a picture. And then he filed it with the Copyright Office, and he listed Creativity Machine as the author. And the Copyright Office said, no, the author has to be human. There has to be human creativity involved. So that case was about whether a copyright may be registered for a work of art if a machine is listed as the work's sole author. Nothing in the law categorically excludes AI activity or human works created with the help of AI from fair uses protection. That case had nothing to do with fair use. It had to do with copyright registration, whether you could get the copyright to begin with. Here's the basic principle we keep coming back to. Anthropic cannot be held directly liable for any outputs reciting publishers' claimed lyrics because, as a matter of law, Anthropic did not act volitionally in producing those outputs. Rather, it was users, mostly if not always publishers themselves, who directly caused the purportedly infringing outputs. Yep, they're the one that caused all the harm. And now they're saying, hey, you need to pay us for all that harm that we caused. Crazy. Publishers have failed to show that any of the prompts that generated the purportedly infringing responses were submitted by bona fide third parties. In any event, Cox, woohoo, is fatal to publishers' contributory liability claim because there is no evidence that Anthropic took steps to encourage users to generate infringing outputs, and because Claude has substantial non-infringing uses. The point of secondary liability is to punish only those who consciously and culpably participate in the unlawful acts of another. Ordinary service providers like Anthropic, who do not want their services to be used for infringement but might not always be able to prevent it, are not liable. See Cox. Publishers appear to recognize that they cannot establish either of their secondary claims. After Cox narrowed the standard for contributory infringement, plaintiffs dropped that claim against Anthropic in Concord 2, and yet they maintained it here. And then they go on a bit about what's been going on in the background. After 2.5 years with Anthropic asking the publishers, hey, drop this with prejudice, do it, come on. They're like, nah, we're good, we're gonna do it. The night of Anthropic's filing, publishers filed a notice of voluntary dismissal. Because they realize they're losing now. Publishers should not be allowed to abandon their claims to avoid an adverse judgment while holding open the possibility of asserting these same meritless issues again in Concord 2 or some other future case. They'll go, okay, we'll drop it, then they file again. Okay, we'll drop it, then they file again. And they just keep jerking you around through the courts, because the process is the punishment. They jerk you around, taking up your time, raising your fees. That's exactly what the Sandy Hook plaintiffs did to Remington. That case should have never been let in the door, but they just kept jerking him around, one thing another, until Remington went bankrupt. That's something they really need to start cracking down on. After defending against these claims for years, Anthropic is entitled to finality. We need you to say it, Judge. We need you to give us a ruling, so we'll know what we are and are not allowed to do from this point on. And so that they can't come back and just keep doing this over and over again. To prevail on their secondary liability claims, publishers must establish that a bona fide third party generated the allegedly infringing output in question. The predicate act of direct infringement cannot have been committed by publishers themselves. I hope Midjourney's paying attention so they can make this same argument over in the Disney case. Because like I said, none of them were infringing. Publishers, citing work product protection, have refused to produce evidence that would allow Anthropic to confirm whether in fact those outputs were generated by a bona fide third party. Publishers asked the court and Anthropic to simply take their word that those outputs are not part of the nearly 10,000 prompts that publishers submitted during their pre- and post-suit investigation. 10,000! And what, there was less than 500 infringing? It took them 10,000 tries to get all of that. Do you see what I've been saying about this? That's why this is so important. By withholding evidence, that would allow Anthropic to assess publishers' factual assertions, publishers impermissibly use privilege both as a sword and a shield. That's an important doctrine there. Attorney-client privilege is sacrosanct. There's not much that can pierce it. So if you're defending yourself in a lawsuit or a criminal case, and they want to know, hey, we want to know what you said with your attorney. Nope, you don't get to know that. But if your defense is, well, I consulted my attorney and he said it was legal, then they get to pierce attorney-client privilege for the purpose of those particular conversations in order to establish that your attorney actually told you that. So that is where you're using it as a sword. You're using it as an attempt to make your case. You cannot then go and say, oh, you can't see those conversations, they're protected. No. It's one or the other. And here, they're not using attorney-client privilege, they're using work product, but it's the same thing. They did all this prompting and got all these results, and they say, here you go, this is what we did. All right, let's do discovery on it. Oh, no, that's work product. It can't be both. It can't be both a sword, something you're using to make your case, and a shield, something you want to protect from discovery. Can't do both. And check out this footnote. Since filing their motion, publishers have admitted that one of the outputs characterized as an undisputed third-party output was generated by their own expert. Publishers made this correction only after Anthropic identified the issue. Ooh, they caught ya! They caught you. They were like, hey, wait, that one's made by your expert. Oh, man. Do you see how dishonest these people are? Under Cox, contributory infringement can be shown only in two ways. If the defendant actively encourages infringement through specific acts, or if the provided service is tailored to infringement such that it is not capable of substantial or commercially significant non-infringing uses. Publishers fail to produce evidence of either. Publishers have pointed to no expression, let alone clear expression, from Anthropic that its goal in training Claude was to promote or foster infringement by third parties. Nor do publishers have any evidence that Anthropic engaged in specific acts to encourage infringement. All this is surrounding Cox. Again, the undisputed record shows just the opposite. Anthropic implemented and improved guardrails and other techniques to stop that from happening. They didn't want it to happen, they tried to prevent it. And remember, that's not even a requirement. And even if you just know that it's happening and you do nothing about it, that was what Cox did, and the Supreme Court said, nope, not enough. You have to have those two factors. Nor could any reasonable jury find that Claude is tailored to infringement. Publishers cannot show that any user paid for Claude on a per-use basis. Some Claude accounts are free, generating no financial benefit for Anthropic, and some Claude accounts are flat fee accounts that charge a monthly fee independent of usage volume. And just like in Cox, they don't make more money from infringing prompts than non-infringing. They get the same amount of money no matter what you're prompting. Publishers therefore have no evidence that Anthropic received a direct financial benefit from any specific allegedly infringing output. So that's it. Here at the end they say, this case can and should be resolved at summary judgment. If the court finds that 1. Publishers' training claims are barred by fair use, 2. Anthropic is not subject to direct or secondary liability for publishers' user output claims, and 3. Anthropic has not intentionally removed CMI within the meaning of the DMCA as a matter of law, this case is over. At a minimum, the court should hold that genuine disputes of material fact preclude summary judgment in publishers' favor, because the publishers are going for summary judgment too. They want to win without a fight. Well, Anthropic's giving them a fight, and it's a good one, especially now that we have Cox v. Sony. Oh, so many cases that it's having such a good effect on, and we'll keep looking at them. I hope you'll keep looking at them with me, so please, comments for the comment god, shares for the share throne, please hit like, subscribe, and the bell, and of course, donate.pagosity.tv to keep me doing this. Thank you so very much for watching. Until next time, stay strong and be free.